Hi, good morning, good afternoon, everyone. This is Sang Kim, Senior Counsel here at Visa Nation, joined by Managing Attorney Shilpa Malik at Visa Nation. And welcome to our webinar regarding self-petition green cards. This is a continuation of previous webinars that we've been hosting this year. Some of the content should be, familiar to those who attended our previous webinars and are attending here. We're going to go into a deeper dive on some of the case types we're going to be talking about. We welcome you to add your questions to the chat, depending on how you're viewing the webinar today, whether on LinkedIn, YouTube, or whatever platform. We'll set aside some time at the very end to answer questions. We ask those who are attending to please refrain from asking questions where you are sharing your personal or sensitive information. Keep the questions generalized. And this webinar is specific to green card strategies that we will be talking about. We may or may not be able to answer questions that touch upon that as far as visa questions. We just kind of let you know in advance that some of these questions will not be able to answer because they're either not pertinent to the webinar or they're sharing too much information, in which case we invite you, as always, to please visit our website where a lot of this information is contained in greater detail, as well as being able to book a consultation or contact us directly with your questions and concerns. Before I begin, Shilpa, do you have anything you'd like to add before we start our webinar today?
Well, hello, everyone. Welcome to the webinar. We're really excited to share our ideas and suggestions with you. And hopefully these ideas and suggestions will be beneficial in terms of knowledge gathering, and in some of your cases may also lead to possible solutions that you've been looking for. As Attorney Sang Kim pointed, please feel free to ask questions, pertinent to this topic. As he rightly pointed out, we will not be able to get to questions that are not relevant to this topic today, out of respect for people who have specifically signed up with this particular webinar to get answers or direction on green cards, which are self-sponsored. So we welcome you to please post your questions, and hopefully you will find a lot of benefit from the suggestions we're going to be sharing with you as part of this webinar. So welcome.
Thank you, Shilpa. Okay, so overall, today's presentation focused on 4 different types of petition types related to the immigrant visa process. These are based on the I-140 form, which are for employment-based opportunities. We are not going to be talking about anything regarding families or other special immigrant classes. Also, the point of this webinar was to highlight these 4 types because they, based on our clients and our feedback from peers and other sorts of experts and leaders in the field, we find that these are the most adaptable towards a self-driven or individual-driven process. The approvability and flexibility will depend on the circumstances, but we hope that the information, the context we provide based on what USCIS is looking for, as well as what we have found as we work through our clients' cases, can be of value and interest to you as you either pursue more interesting inquiry into the subject or actually begin engagement and initiation on these case types, whether with Visa Nation or on your own or with other providers. So with that, let's talk about probably the most popular petition type based on volume and interest is the EB-1 extraordinary ability. Highlighting on broad strokes, this is a top of the field petition. It means it demonstrates that based on your individual background and your professional or scientific or technology or business achievements, you have demonstrated that you have achieved a sort of recognition, acknowledgement of your acclaim and eminence in the field of your expertise. Now, USCIS has specific guidelines, which I will show you in the next slide, as far as what they find as approvable evidence. So though you yourself may be in a field where you have a lot of peers, a lot of recognition and success, it does not always translate to a green card approvability. The evidence threshold is quite high. There is a common misunderstanding among our clients and peers that minimum means approvable. And so, what I want to kind of emphasize in this webinar today is what has been proven to be successful and what has proven to be more challenging regarding getting an approval in this category. So I'm going to move into the next slide, which provides much more detail of what USCIS is looking for. I'm not going to list out each of these, but I'm just going to highlight how our clients approach this for their individual strategy. So USCIS does require a minimum of 3 of these criteria. And USCIS does also provide what they call a catch-all. So if none of these apply, but you do have some sort of evidence, whether it's a lesser award, a certain membership achievement, some sort of recognition or knowledge that you in your specific industry can demonstrate, which does not quite fit into any of these, then it will be accepted, but it will be viewed by a USCIS officer in that context. Something I kind of explain to my clients when they come to me about approaching the strategy is the first thing I want to mention to them is that USCIS doesn't have like a team of experts. They're not business professionals. They're not sciences professionals. They are essentially administrators and bureaucrats and officers who are running off a checklist revised by their managers and the team at large, which are revisited. So to extent they will not be able to assess your specific achievements or contributions by itself. They want to see that overall you have been written up in publications, in press, in media, that you have been recognized and invited to conferences and panels, that you have achieved business projects and success that is easily corroborated by third parties. So simply being able to show that you have a high salary, that you are respected by your peers, that you have high scholarship from your undergrad and graduate schools, those by itself have not been seen to be successful. So in other words, being successful and being recognized by your peers is a good start, but it is that third party corroboration. It's where your name and your success can be verified by people who are not interested in your green card approval. So that's why in the criteria you see below, there's a lot of evidence of your contributions verified by organizations, professional associations, media, press, not web blogs, not like tweets, not like YouTube content that has a lot of views, but what a reasonable person would say is that they are a business professional written up in Forbes, in Insider, in Fast Company. They have if you're a researcher contribution, you can look at Google Scholar and see that you have hundreds, dozens and dozens upon citations in the field. You've been invited to conferences. You have spoken at eminent panel discussions like TED Talks and others. So it's kind of when you see it is the best way I can explain to you the challenge that is presented to you. So before I turn it over to Shilpa to add any final comments, for those who are early in their career, who just graduated from their master's or PhD, and they're off to a really good start, this may be a blueprint for things you will be doing in the next couple of years to demonstrate an approvable green card effort. It is something you can do more than once. It is a lot of effort, so there's a reason why many people don't keep trying over and over again. But again, this is not something where a past denial or past unsuccessful efforts closes off the opportunity for a future one if your profession continues to evolve. And I'll close by just saying is one of the best pieces of advice I give to my clients who ask about these is that your professional achievements is something I imagine you want to do in your growth and in as you strive to be the best in your field or the top of your field for your own personal and professional interests, and which are completely aligned with towards a green card approval. So one is not counterproductive to the other. Continue to excel and achieve your goals, and those continue to be demonstrative towards a future green card or a current green card effort. Shilpa, did you want to touch upon anything I discussed?
No, that was an excellent presentation, Sang. The only couple of things that I thought about while you were talking about it was that I would recommend clients to remember there's a requirement of sustained national or international acclaim, which means you may have had achievements 5 years ago, 10 years ago that would have maybe qualified you back then. But if at this time you're not doing it, and for the last few years you don't have that same recognition, USCIS is definitely going to question it as to why has that recognition not continued till date. So that's very important to remember. It has to be past, current, and likely future as well, because what you've done in the past is definitely indicative of what's going to happen in the future. But they also want to see that you're currently still doing the same thing, and it is deeply connected to the field of extraordinary ability that you're claiming. And one more thing that I would like to add is that you should have risen to the top of your field. So if I would just take an example here, if we're talking about, let's say, a chemical engineer with a PhD, there could be many out there who have done a PhD in essentially as far as chemical engineering is concerned. But what is it that that person has done different from other individuals gotten a PhD in the same area? Have they published? Have they invented something? Do they have patents? Are they working with organizations where their expertise is so much in demand that they're being paid a very high number, and there are products that they're creating that are extraordinary in nature? So please remember these guidelines while you self-assess your qualifications to determine if it's worth your time to reach out to an attorney who's qualified in this area to seek further guidance. Thanks, Sang. That's all I needed to add.
Thank you. Before we move on, I did want to provide a little bit more specificity to what we have seen work and not work as far as the criteria. And thank you for your question regarding fees. We'll touch upon that later in the Q&A section. But thank you for raising it regarding the recent fee increases and changes, which is understandably causing some confusion regarding the cost expectations. So going to spy from top of the list to bottom, when they talk about major prizes, a lot of our clients come back with scholarships, things they achieve while they're a graduate student. And I can say, unfortunately, that is not deemed to be a demonstration of extraordinary ability. The reason why is that the prizes need to be of a caliber where it's recognized on, as Shilpa said, on a national global level. A student body, even at a prestigious university, may not be considered a large enough size and a large enough selection of criteria to demonstrate that they are at the top of their field. Membership associations, want to be clear that there are many great professional associations, but simply paying your dues to be a member of an association is not demonstrative of extraordinary ability. If you achieve a certain level within the membership based on your achievements and contributions, senior member, lead member, that definitely, or even a board member or a voting member of the organization, that is definitely stronger evidence than simply paying a card to be part of, for myself, ACLU and other sorts of law field organizations. Publish material about your professional or major chart publications. This is simply a matter of fact. Have you been written up in something that is high profile? New York Times, Forbes, Scientific American. These are major known publications. Now, if they're more specific to an industry or profession, that is acceptable, but you're going to need to show evidence of its circulation and volumes. That's why when I mentioned that an individual blogger or you posting something on Medium is not going to be demonstrative of you achieving a published claim in your field. Being asked to be a judge of others, again, this is fairly self-explanatory. Again, probably will not be valuable if you are a judge of, say, inside your own company for an internal company's awards. Again, it's the scope and size of the awards of what you judge, of who you're judging and how important it is. that is, moving towards extraordinary ability. It's that what does this demonstrate is what you should be asking when you present a piece of evidence towards your provability. Original contributions. This is the success. These are the things you can touch upon. These are the things that if you were talking at a presentation, at an interview, what can you say that you've done? Did you, deliver on a major product? Did you start up a company? Have you developed a research publication that has been heavily cited? It has to be something that you can articulate, and it has to be demonstrated again by the evidence. Authorship of scholarly articles is fairly self-explanatory, must be peer-reviewed. Your work has been displayed in artistic exposition or showcases. Again, EB1's not just for science and business, but it's also for arts and sports and athleticism as well. Leading a critical role in distinguished organizations. This again is if you were the VP or the lead scientist or the head researcher, or you were critical on major projects. This one is actually the most easy one to demonstrate simply by having your employer sign off on a letter saying, you were someone who was absolutely leading in critical need, and here's why, and here's how they led to success. And I'll close with the high remuneration salary as well as commercial success. These are a bit subjective. We have found that Department of Labor has wage data for your profession in your specific field. So achieving the top of your salary is not really what is demonstrative towards extraordinary ability in my experience. It is going far beyond it. Seven figures, high six figures, a major bonus, major profit equity sharing. These are things outside of just a well-compensated top of the field salary is what USCIS is looking for. Again, feel free to ask your questions in chat, but we're going to move on now, and I'll turn this over to Shilpa to talk about the nuances of what's called a multinational green card strategy and how our clients who are driving their own success in business and enterprises may be able to use this strategy. Shilpa?
Yeah, hi, thank you, Sang. So I just would like to bring an EB1C, multinational executive or manager category, to your attention as well. This is something a lot of people do not necessarily think of as a first idea when they're thinking of moving to the United States and self-petitioning for a green card. This is also not directly a self-petition because it is what's called the mother of an L1A in some cases, where you do have an organization that you're working for overseas that was likely established by you as one of the majority shareholders, and then you open a branch or a subsidiary in the United States of that office. You make it successful for a year or two, because one of the criteria of an EB1C multinational executive or manager green card is that the company in the US should have been in business for at least 1 full year before this process can be initiated. Secondly, the company should have employees, should have good revenues, it should have a strong foothold in the United States before you actually have that company sponsor you. Now, it's very important to understand that even if you're a majority owner of the US entity, then you still need to prove everything else. You have to prove that you previously worked overseas for an affiliated or a related company of the US company for 1 full year before moving to the United States in the 3 years preceding your entry into the United States. And number 2, there is an employer-employee relationship between the US entity and yourself, where despite being a majority owner, there could be an independent board of directors, or the entity by itself has the power through other means and other members who could fire you for various reasons. So they need to control your employment in other words. So essentially, EB1C for multinational executives or managers requires us to prove, especially in an executive role, you need to prove that you are making policy and business decisions on behalf of the company, and you are not necessarily a people's manager, but the company's business operations are under your control, and you're establishing the goals and policies of that company. In a managerial capacity, you may have a team of people reporting to you at professional levels, or you could also be managing a critical function within the organization, which is core to the business of that entity. So this is one of the options that you could pursue. Again, this does not have to go through the labor certification process. There could be a direct I-140 filing, saving quite a bit of time, which is consumed by the Department of Labor process of labor certification. However, I would like to remind you that these applications are very deeply scrutinized by USCIS to ensure that all the criteria are satisfied. This does not require a showing of extraordinary ability, but what it does require is proving that you've worked for 1 full year overseas in a multinational executive capacity, and that your permanent move to the United States is needed for the US entity to grow under your guidance as an executive or under your role as a manager. We can now move on to the third slide, Sang, unless you would like to add something here.
No, this is great so far. Thank you, Shilpa. So this slide we're talking about here is for those whose manager is not necessarily one of either what Shilpa described as far as an executive, VP, president, CEO, or a manager where you're managing your direct reports, but you're managing more of what's called the function, meaning that there's a division, a project, a specific major part of the company that can be articulated that you're managing, and you're managing them because you're indirectly managing people or team leaders or even vendors or third parties, then this is still a way for you to get the I-140 approved. Again, this is something where you are, as the slide shows here, based on USCIS definitions. This is again self-explanatory. You not just by your title, but you're operating in a way where your scope and your responsibility is a huge critical part and can be demonstrated by not just statements, not just a support letter or attestation, but verifiable email communications, project documentation, you signing off on things that are where budgets and resources are being expended on behalf of the company towards its success. These are the things that we find to be very supportive and helpful towards the demonstration of I-140 approvability in this category. But having said what we said at the top of the call, we imagine that this is going to be mostly valuable for those entrepreneurs and business leaders who are trying to grow their business. So in a sense, you'd probably be applying as an executive or manager. You wouldn't have to really, the functional management can be an extra bit of support and strength to your case. But we, in the scenarios where we work with our clients on businesses that they are driving themselves based on their funding or VC capitalizations or other sort of third-party funding, this is something where by creating a legal entity, you are driving your own process towards a green card. So is there anything you want to add, Shilpa, before we take a moment to kind of answer some of the questions that have been arising?
No, I think you've covered it all as far as functional managers is concerned. So at this time, we've covered an EB-1A and we've extraordinary ability, and we've spoken about an EB-1C, which is the multinational executive manager category. I just wanted to quickly go back to the EB-1A and also add in furtherance to what Sang said. He did talk about academic awards, but even awards that you get within your company will not be considered by USCIS unless obviously that's a very top-notch award that's recognized in the industry. So sometimes we get clients reaching out to us say that I got the Employee of the Year award or I got the Executive of the Year award. So it may be an internal award within your company, but USCIS is not going to give it as much weight as you getting an award in an industry conference where there are multiple organizations that kind of appoint you as the awardee. So something to just keep in mind.
Sure.
We can Sang, address any of the questions that you feel.
Yeah, let's go ahead and take some of the questions here, and I will get to the fee question at the end. I tried to copy paste it, but it wasn't coming out very clearly, so I'll do it later on. Again, to the question, and I apologize, it's not coming up in Western characters. In your opinion, the award of who's who, would it be considered workable? My sense is no. Who's who's been a while for quite a while is recognized as a fee-based recognition where you are used. It's for marketing. So there's nothing wrong with who's who. It's highly published, but it's fee-based, and so you being invited to pay the fee is not demonstrative of extraordinary ability. There won't be a recording of this, but we will. Feel free to contact us after the presentation, and we're happy to send you a copy of the slide deck here. Thank you, Nina, for your question. Can you explain affiliate relationship? Does a U.S. company need to be profitable, or is it important that it has a lot of revenue? So, to the first question, affiliate, it can be defined in different ways. But how I've seen affiliate demonstrated is that there is a U.S. company, and the U.S. company has opened up a branch or affiliate of its organization in another country. Now, the key thing is that there needs to be a legal entity in the other country. So either the U.S. company can own it 100%, the foreign company be the parent and own the U.S. company. These two companies can be owned by a joint owner. But the first part needs to be demonstrated is that there needs to be more than one legal entity. So that legal entity must have been created in that country according to their laws. Second, that country, those two companies have to have some sort of connection that is verifiable by documentation, either shared ownership or one of them owns the other, or one of them is a branch of the other branch. Now, to the other two questions, does the U.S. company need to be profitable? No, it does not. It's many companies operate at a loss. Many of the top technology and startup companies go years, if not decades, without any sort of profitability. It's a question of more of the latter, revenue, whether or not it is doing sufficient business activity. Is it employing people? If it's just you and one other employee, and there's one employee abroad, that's going to be not a strong case, because unless you can demonstrate that it is exercising a disproportional amount of revenue and activity, that demonstrates that even if there's only X number of people, it's doing X number of revenue several times over. So again, this is one of those, you see it, it when you see it. The minimum is not necessarily going to be the approvable. So we can, our team has had success in filing cases that have been challenging, that are where the company's young or the evidence is not quite there. This webinar is explained to you what is considered to be the strongest case available. So we want to contextualize and frame our answers to that extent, not in the sense of what can I get away with.
I can take the next question, Sign.
Sure.
Yeah, just bear with me. I'm just pulling it up. So how's it different from the L visa? The L visa is a non-immigrant visa, while an EB-1C is for permanent residency. Generally, people come to the United States on an L visa prior to applying for an EB-1C. L visa is limited for up to 7 years. It's approved in 3-year increments. The criteria is more or less the same for both of them, but I'm going to keep this answer really short. Again, L is a non-immigrant category of a similar based sort of setup, whereas an EB-1C is for permanent residency. And Alina, just to address your question that the Who's Who Award is not fee-based, and thank you for letting us know your name. The reward is performance-based. They will look at the performance metrics. They'll look at what is the consideration for giving this award. It may not be fee-based, but what are the parameters under which the award is given is also taken into consideration. So having one award, while it may be, which is well recognized, is helpful, but of course we have other criteria for an EB-1A that also need to be satisfied. And every case has to be assessed in its totality to determine whether a person can qualify for an EB-1A. So thank you for providing that information. Now, insofar as an EB-1C, does USCIS require financials from the foreign subsidiary? Yes, it absolutely is required, because we have to show that the company overseas is also fully operational and is conducting active business in that country. And the only way to establish that is through financials such as tax returns, financial statements, ongoing proof of business activity, bank statements, etc. So now, Sang, if you want to take on Alina's question, then we can move on to the remaining 2 slides of our presentation.
Yeah, and to close, Alina, based on the new fee requirements, you're paying the $715 for the I-140 and a $300 for the asylum program fee. That's required. Let's move on to the national interest waiver case. Shilpa?
Absolutely. So EB-2 is for people, the national interest waiver categories for people who either have a master's degree, which is an advanced degree exemption for people who have a master's degree or higher in a particular field, or a bachelor's degree in a particular field plus 5 years of progressive work experience, they become eligible to apply. And there's also a second set of people who can apply, who can demonstrate exceptional ability in their field of endeavor, not to the extent that's required for an EB-1A, but to a lower extent, where you show that the work that you're going to be doing or have been doing is in the national interest of the United States. That's a very, very critical component of this filing. You have to show that your endeavor, your business strategy, your business idea, or whatever it is that you're doing at the moment, whether it's as a scientist, researcher, business person, as an artist, etc., is going to benefit the United States as a whole. We get a very wide range of interesting cases for NIW. You can be working in any field as long as we can show a connection between what you do and the benefit to the US and your qualifications meeting the criteria. It's something you can definitely pursue. It's especially advantageous for people who are not eligible for an EB-1A, but are not necessarily, candidates who don't have an employer who's willing to sponsor them for an EB-2 or EB-3 green card, but have a very strong case for a national interest waiver. So some of the major criteria for, at least some of the criteria that were established by the Administrative Appeals Office in the matter of Dhanasar were that you are well positioned to further the endeavor that's usually established by the work you've already done, your qualifications, any recognitions you've received, any recommendation letters you can obtain from experts in the field, any original publications you may have, depending on the field you are in, or the success that you've been recognized for through media articles. Again, as for an EB-1A, third-party corroboration is very, very critical for an EB-2 national interest waiver application too. Now, when we move on to substantial merit and national importance, it means there has to be some value to the work you're doing, which is of interest to the US government. Obviously, if it's not meritorious, the US government is not interested. So these things go hand in hand. Then the last thing is it would be beneficial to the United States to waive the requirements of a job offer from a prospective employer or the cumbersome labor certification process through the Department of Labor. What really happens in that scenario is that the US government needs to see that you are so special, or in your field, and the idea that you're presenting to them is so solid that they don't believe you really need a job offer. Just by waiving this labor certification process or a requirement for you to get a green card, they acknowledge that, yes, we like what you're suggesting and we see the value in it, and it's in the national interest, and it's likely to be in the national interest of the US. One thing that I do like to tell my clients is that you don't have to show past success necessarily in the endeavor that you're presenting to them, but you have to feel very strongly about it in order to convince an officer that, hey, this is a great idea. This is definitely going to benefit the US. There's an economic benefit. I'm going to create jobs. There are other, not so tangible benefits, which are still in the national interest of the US. So you have to get very creative with it, but it's a great solution for a lot of our clients who come to us, and we review their cases and are able to successfully represent them in EB-2 NIW filings. Sam, we can go on to the last slide unless you would like to add something here.
Yeah, thank you, Shilpa. I'd like to add just two things of note. One is that regarding substantial merit and national importance, I do want to emphasize that based on cases we have seen, that simply stating that your endeavor or your national interest is to improve the economy by itself will not be a national interest. This is something that many petitions have tried and were unsuccessful in being a generalized net positive impact as far as creating jobs or creating revenue for the United States, or stimulating the economy. That by itself has not proven to be successful. It's the specificity of what you are doing where it will incidentally also improve or create jobs or the economy is where the approvability comes in. And finally, as Shilpa said, the EB-2 is definitely a strategy that is workable if you're lacking some of the EB-1A requirements we discussed. But I understand for a lot of our callers as well as clients that EB-2 is a more backlogged category. It's something, but it is definitely going to not be as much value as for those who are country of birth was subject to the country backlogs in China, India, Mexico, and Philippines. So with that, I'll turn now to the final category. I'll spend a little time on this and then move to the questions, is the EB-5 investor program. frankly, this is, the slide speaks for itself. This is a very much a capital-based green card endeavor. So, for those clients who are interested or are considering this, some things to keep in mind is that the capital needs to be of qualified vested funds. In other words, you can't simply get loans or or leverage credit towards the capital needed. It does need to be vested or out of pocket, as it were. So this is what is considered to be kind of the biggest challenge for a lot of our clients, to make sure that liquidity is available, towards this green card effort. But having said that, whether you do it as an individual or through one of the qualified regional centers, this is definitely a possibility if capitalization is not really an issue and it's more of a pathway towards a green card. So with that, let's take some more questions here. And thank you so much for posting them as we've been discussing. What about working remotely from any of the U.S. company? What is the criterion category? So Patel, I imagine you are either talking about EB-1C multinational manager or any other categories. So the I-140 green card effort is for a U.S. opportunity. So the expectation at some point is you're going to be in the U.S. There is no visa based on filing the I-140. So if you were to pursue extraordinary ability, multinational manager, or national interest, that by itself does not provide you any sort of travel or work authorization in the U.S. Until that is approved and until the green card is filed and processed, you won't have work or travel authorization in the U.S. So I invite you to come back to us directly about this question regarding what your timeline and strategies are looking to. Next question from Zoliswa. Apologies for the mispronunciation. Is how long is the average duration from filing of an I-140 to a green card these days for? I actually don't know this acronym. ROW candidates. If you can explain that in the chat, I'd be appreciated. I will say, generally speaking, for EB-1 green card efforts, if successful, the I-140s are taking about a year or so. You can always pay for expedited processing, which accelerates the processing to about a month. And then if your green card is available, or rest of world, thank you. If the green card is available, we use the terminology worldwide. If the green card is available, which unfortunately for right now, EB-1 is backlogged. So there is both the I-140 processing times, which can be a year or several weeks or months, depending on how whether you do expedited processing. Then there's the backlog wait time, which can be much longer, could be several months or a year. And then there's the actual 485 green card processing, which has been taking anywhere from 6 months to a year, based on which jurisdiction you're applying for within the U.S. So overall, optimally speaking, you can look at anywhere from 2+ to 3 years plus for an entire I-140 green card process. And as I touched upon before, the process does not provide you any sort of presence and work authorization or travel authorization until you get to the final step of the green card process. So that's why many of our clients either wait abroad or they're in the U.S. on some sort of separate visa, like an F1, an L, an H, and O visa.
I can take that, Stang, if you
Sure.
want. Yeah. So again, Stang rightly explained. Even EB-1C takes time. Generally, it would take, if for a successful EB-1C petition to translate to a green card for the worldwide category, it would be about 2 years, since it takes time for the I-140 to be processed and approved, even if it's approved under premium processing. The immigrant visa process for somebody who's overseas can be a year and a half. And if the person's in the United States on a valid non-immigrant status, then it could be about a year for the I-485 to be processed. Now, to take on the question of Muhammad Usman Hassan, do we provide free initial screening? It all depends. I mean, if we will be happy to look at your resume, but if in order to make a full assessment, we would eventually require you to schedule a 20 to 30-minute consultation to discuss your qualifications and to understand that this can be taken forward. And for Ellis Moss, how many letters are needed for an EB-2 NIW? There's no magic number, to be honest with you, but we typically do recommend anywhere between 4 to 7 letters at the very minimum. If you can get more, even better. But it's not the quantity of the letters that matters, it's the quality. You could get one-page letter saying you're great, that's not enough. They have to be very specific in nature, addressing how do you add to the benefit that you are proposing to the United States government, and what is it that makes you uniquely positioned to do that. So there have to be specific examples. So please focus on quality, not quantity, and focus on the people that you're getting the recommendations from to make sure that they're well known and recognized as experts in the field that you're trying to get the green card in.
Yeah, I'll take the next question. Okay, so Niraj, I want to emphasize bold-faced underline. There is no EB-1 national interest. There is none. It's only EB-2. So for an EB-2 national interest, if someone is working in the field for which there's a shortage, are they eligible to apply for this too? So yes, there is an if you're talking about Schedule A or one of the other sorts of lack of that, you're kind of confusing two multiple categories. So a shortage can be helpful towards a national interest case, but it's not an EB-1 category, it's an EB-2. And shortage does not, there's a shortage that's based on the Schedule A category, and that's also EB-2. That's not an EB-1 either. So, just to kind of emphasize, there are multiple ways you can approach a strategy. You will likely want to figure out which one is the best strategy for you, whether it's EB-1 extraordinary ability, EB-2 national interest, or EB-2, EB-3, Schedule A employership. So it's going to be based on your specific circumstances. So again, feel free to book a consultation or contact us if you have any follow-up. We'll take one last question and we'll end our webinar for today. We want to thank everyone for their attendance today. If you have follow-up questions, feel free to contact us directly. Again, we're happy to share this webinar. It will also be available again on LinkedIn for replay, based on our past webinars. So Patel, was your last question. For the investment categories, what are the pros and cons for each applicants? Where to invest, that's going to be based on your subject matter expertise as a entrepreneur in business. It's going to really, again, I want to reemphasize kind of what I talked about before. Your personal and professional interests and your goals and the things you believe in, are passionate about, and the things you want to succeed in should be aligned with your green card strategy. You should not be trying to lock yourself into a strategy because of things you read in forums, people speculate about where to put your money or what businesses to get into. Yeah, there's a lot of opportunities in technology. There's a lot of interest in small businesses. This is so outside the EB-5 category, which has a specific capital threshold. A successful business is going to be self-evident based on how you pursue it, whether you pursue it as a multinational manager strategy or you pursue it in the sense of achieving a lot of acclaim in the field for your startup or new business, and that translates to an EB-1A category.
Sang, I just wanted to quickly, this investment topic brought me to EB-5 as well. I don't know if you wanted to touch on it just for a couple of minutes so that our clients can be advised, or the viewers can be advised of an EB-5 investment option as well.
We've already, the slide is here again, and so this is a specific capital requirement, and the capital requirements must be fully vested in yourself and not loans. So Patel, I hope that's what you're referring to, and but like I said, look at the slide deck, look at this presentation again at your convenience. Go to the USCIS website, which outlines exactly what the requirements are for EB-5, or feel to contact us for a consultation. This is, generally speaking, there isn't a category of business. There isn't, if your family is interested and you want to work together, absolutely look into that. But like I said, the two highlighted numbers here are pretty much exactly what you're going to be looking at. So with that said, thank you again for your time and patience. Thank you again for all your great questions. We'll be holding more webinars throughout the year. But yes, if you have a specific question or look to see get our advice or counsel on anything, feel free to visit us on the website. And we wish you the best in your pursuits and endeavors. And thank you again, and talk again soon.
Thank you, Sangha. We really appreciate you all joining us today. We do understand that this was a synopsis of the options that might be available. Please remember, one size does not fit all. Every case has to be reviewed independently. So if you have any specific questions, feel free to reach out to us. This is what we're here for. And we wish you all the best, whether you choose to work with us or any other law firm. Please make the right choices, and good luck to you all.